To be clear, sir, I'm not suggesting that the Canadian interrogations are the reason why he's being detained. I am suggesting they're the reason why he was subjected to the sleep deprivation program in March of 2004. He was subjected to that treatment by some American officials who knew that in the previous Canadian interrogations, the intelligence that had been elicited from Mr. Cotter was high-quality intelligence, apparently, and it was described as highly successful interviews from that point of view. Now, that intelligence has been edited out of the materials that are before the court by Justice Mosley.
But you're not saying that Canada was complicit in the sleep deprivation. You're saying that Canada's complicity was in conducting the interview following the sleep deprivation.
No, I'm saying that Canada is complicit in the sleep deprivation, and I'm saying that Canada is complicit in the other violations that were going on at the time. Now, on this point, firstly, setting aside the sleep deprivation for the moment, if you recall Cotter 1, and obviously you know what you said in that case better than I do, but as I understand it, this court said that by participating in these interrogations, Canada brought itself into violation of its own, Canada's, obligations under international law. The court did not take the next step and say those are also charter violations, but the court did say that the degree of participation in these interrogations was sufficient to bring Canada into violation of the Geneva Conventions and also the international law instruments which accord detainees a right to habeas corpus. So in terms of the violations that were going on at that time, we say, yes, they were complicit. They weren't the ones who captured Mr. Cotter. They didn't first put him into the system, and they didn't write the rules governing the system, but they decided to step into that system and participate in it, to benefit from it, to share the benefits of that participation, and we say that is complicity. Now, since then, of course, we've learned that in addition, Mr. Cotter had been subjected to the sleep deprivation program prior to the interview in March of 2004. And we also know that that was inflicted on him for a specific purpose. It wasn't just for fun. It was to make him more amenable and willing to talk at the Canadian interrogation. So it was made with a particular view towards these interrogations. And we can tell you there were no other interrogations that occurred during this period. So we conclude from that the Americans said, okay, these Canadians are coming. We're going to prepare Mr. Cotter for this interrogation by putting him through this frequent flyer program. And Canada knew or ought to have known that that was a possible consequence of that participation.
The additional information that you obtained following the first case here was that the Canadian officials knew about that sleep deprivation program at the time they interviewed him. Am I correct? They knew about it. You seem to be suggesting, perhaps not, but I want to clarify that they also knew that this sleep deprivation program was planned by the Americans for the purpose of that interview. Was
well,
that information
all I
provided
can see
as well?
from the document is that the Canadians were told that it was to make him more amenable and willing to talk.
But at the time they went to the interview, or was there a complicity before that? Well, let's have this Canadian frequent flyer program before we get there. So
they were not told about the frequent flyer program before they got there.
Okay.
Okay. They were told from the outset, from from February of 2003, by Mr. Cotter himself, that he had been tortured. He told them this over and over again, and they ignored it. So when you look at the judgments below, the courts below have found it sufficient to say, well, prior to the March of 2004 interview, the Canadians were told about the frequent flyer program, and we agree that that is sufficient to ground a charter violation, but we emphasize it was not news at that point in time that Mr. Cotter was being abused, because Mr. Cotter had told them that repeatedly way back in February of 2003, and they kept coming back for more interrogations.
Just on that issue, Mr. Cotter, it appears in the record, complained that he had been tortured, but he had not given any detail as to what kind of treatment he was subjected to.
I think that's probably fair. I don't think that he gave a detailed account of what the torture was.
And do we know exactly when Mr. Gould was told about the sleep deprivation?
Well, yes, it was immediately before the March 2004 interview.
So it was before you got into the interview room?
Well, let's look at the report. It's at tab 5 of our condensed book, and the paragraph is at page 27. It appears, you know, and the part about the frequent flyer program is in paragraph 6. My reading of this document is that it's not crystal clear, but it was probably just prior to the interview. It was on that trip, I would say. I'm sure it didn't happen before Mr. Gould went down.
Because we can infer that it was prior, but even that report does not say whether the information was conveyed before or after.
Our reading of this document has always been that it would have been before the interview. When you look at the previous paragraphs, it's talking about a number of pieces of information that were provided to Mr. Gould in preparation for the interview. Then you'll see the next section says, the interview, and it talks about the interview. And then there's things that happen after the interview discussed in this document. So our reading of it, it seems fairly clear to us that this occurred prior to the interview.
So therefore, from what we started off on this, this line of questioning when we were discussing Suresh, so again, are you relying on what happened on that day, the interviews, to provide a link between the Canadian government and the Canadian officials and the process that's happening in the foreign country? We have to come back to the interviews, whichever way we go here, do we not?
Well, I hope this is responsive to your question. I'd like to answer in reference to the report that we have at tab 3, firstly, of our condensed book. This is yet another report that was released after we commenced this case. And as far as we're aware, it's the first sort of authority. It's not a case, it's not a judicial authority.
Tab 3 is the executive order of
Pardon me?
President?
Tab 3 is executive.
Oh, I'm
Executive
sorry, I
order,
meant
sorry.
tab 13, 1-3. This is a report of a special rapporteur for the United Nations named Martin Scheinin. And this report addresses specifically the significance under international law of one country participating in interrogations of prisoners who are being held by another country in violation of international law, whether because that prisoner has been tortured or whether the prisoner is being arbitrarily detained. And the whole point of this particular report is for the United Nations Human Rights Council, to be advised on whether this type of conduct constitutes a violation of international law. And if you look at page 60 of this report, you'll see the heading, Participation in Interrogations. So it deals specifically with this subject. If you look then down to footnote 63, you'll see a discussion about this phenomenon generally in Guantanamo. Canada is not the only country to send interrogators there. But one of the countries that is noted by the Special Rapporteur is Canada, and we've underlined the word Canada. And of course, so this report is not just addressing the same general subject. It's addressing these very interrogations that are at issue in this case. And obviously, I would commend all of this passage to you. I don't want to read it all because of its length. I think it's summed up in the final sentence, which is on page 61, where the Special Rapporteur says, therefore, the Special Rapporteur believes that the active or passive participation by states in the interrogation of persons held by another state constitutes an internationally wrongful act if the state knew or ought to have known that the person was facing a real risk of torture or other prohibited treatment, including arbitrary detention. So we say Canada certainly knew he was being arbitrarily detained. We certainly know he was having his right to counsel denied, and so on and so forth. And they also certainly knew, well, Mr. Cotter had specifically told them he'd been tortured in February of 2003. Then they were told about the frequent flyer program in March of 2004, and they went ahead and participated in these interrogations, and at least according to the Special Rapporteur, that constitutes complicity